You're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officers were dispatched to a possession of marijuana investigation at 100 Hollows Tree Lane in Harris County, Texas. Officer was informed defendant crossed unauthorized crossing point from convenience store to apartment complex. Officer observed strong odor of marijuana.
Wait. He did what?
It says he crossed an unauthorized crossing point. So I guess he crossed the street.
Is he jaywalking?
Yeah. Yes, Your Honor. And then
Walking while black.
and it says the officer observed a strong odor of marijuana and he was informed that the defendant had begun to walk backwards upon being asked about marijuana by another officer. A PC search was conducted and the officer observed a large sack of marijuana.
I don't think so. He's walking while black. I don't think so. I'm going to find no probable cause.
Yes, Your Honor.
Mr. Blake, be careful, man. You know, the world is against you. Don't let him be. Do something with your life. You know what I mean? The more you just, come on, man. All right, I'm going to have you just take a seat in back, all right? Hang tight. Ms. Treadwell, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
On September 4th, 2024, officers observed defendant's vehicle failing to maintain a single lane at 2600 Eldridge Parkway in Harris County, Texas. Officers observed defendant's vehicle swerve on multiple occasions, cross over center stripe lane divider, and on one occasion almost strike under the vehicle. Traffic stop was initiated. Officers made contact with the defendant, who was the driver of the vehicle. The officer observed lethargy, slurred speech, red eyes, and the defendant stated she had ingested HGN 6 out of 6, walk and turn 7 out of 8, one leg stand 3 out of 4. Defendant was read the DIC and refused blood. A blood search warrant was obtained and executed. Defendant was ID with a Texas driver's license.
Did you say there was an odor of alcohol as well or no?
No, Your Honor.
Hey, Mr. Don't say anything.
I'm sorry.
Ms. Treadwell, I'm going to find that there's probable cause to go forward with your case. Do you have a Texas driver license, ma'am?
Yes, sir.
Do you have valid liability insurance in your name?
Yes, sir.
Okay, I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You need to understand if you're taking any kind of medication for depression or any other prescribed medication, controlled medication, it's still possible to abuse it, intoxicate, or make yourself, without the ability to drive. If you take too much, if you do something that you're not supposed to, you end up on the street again, I'm going to put you in jail. Do you understand that?
Yes, sir.
Does she have any prior DWIs?
I will check, Your Honor.
If you can run her NCIC. How old are you, ma'am?
32.
What do you do for a living?
I'm a case manager for individuals with mental health and IDD.
Are you married, children?
I have 2 kids. I'm not married yet.
You have 2 children?
Yes, 2 daughters, 11 and 4.
No previous DWI, just a previous theft.
Okay. Did you want to apply for an appointed lawyer, ma'am?
I can't afford it right now. I lost my job due to this incident.
I'm offering you a lawyer. Would you like a court-appointed lawyer, ma'am?
Yes, please.
I understand the stress about this, but don't abuse any kind of dope. Imagine if you go to jail and you don't have anyone to bond you out, who's going to take care of those? Ma'am, Ms. Treadwell, I want you to listen. I know you're thinking about what to say, then you don't listen. If you go to,
I'm gonna listen. Yes, sir.
if you go to jail and I can make your bond $15,000 and you don't have anyone to bond you out, who's going to take care of those 2 little girls? You need to consider this next time you're out there in the free world, because if I find that you're a danger, that you do something to violate these conditions, I'm going to put you in there. I'm not giving you any more PR bonds.
Yes, sir.
You understand?
Yes, sir.
Okay, I need you to fill out an application for me now. So deputy's going to give you an application. After that, I'm going to have you go to Victoria, sign a reset. You will eventually meet with Rachel for your bond conditions, and then we'll have you take your seat in the jury box. All right? Yeah. We'll direct you if you want to head that way. Okay, gotcha. Hey,
How are you?
what's going on?
Judge, I'm here on Mr. Tyrell, Ian Tyrell. He has the bond violation.
Come up, Mr. Terrell. I'm sending you now for a drug test, sir.
Sir.
And then if you ever miss another drug test, I'm going to put you in jail, no questions asked, and I'm going to make your bond probably double what your felony is. Do you understand?
Sir,
As it stands, I ordered you not to consume alcohol or any kind of dope. We're going to test you now. We'll see what it shows, if anything. And then you have other things to do?
Yes, Judge.
You want to, can you come back?
Yes.
Okay, take a seat for me, Mr. Trump. We're going to find out here shortly. Okay. What did you test positive for?
Sir,
Is that why you keep going? I hear you over there, man.
I stopped.
Really?
Sir, I have.
For you to test positive, that means you probably did it within the last 2 days.
Sir,
Okay, I don't believe you.
I did it. I stopped doing it probably about a little bit under a week ago, probably like 4 days ago.
Yeah, okay.
But, like, just being honest, sir,
He
I'm not
admits that
trying-
he used, but he needs help, Judge.
I've
I'm
been-
gonna
He's
give,
getting help.
and I'm gonna give it to him.
I've been going into A meetings and stuff as well.
It's not working for you because you're still using. And I'm not gonna take you coming here and telling me that I've quit, I'm gonna stop. I told you that when you first got here. And that was the time when you start doing what you need to do. You now have shown me that you're incapable of stopping on your own. So I'm taking you in.
Sir,
Goes with you. No, you test positive for cocaine. You have an open felony case.
Judge, we can't put as a condition of his bond some sort of
I
treatment.
already did. I already did, Yasha.
Some help, at least, Judge.
Yeah, I'm gonna have him T-Raz as soon as we get him back in there. And if they say inpatient treatment, boom. But what's his last name again?
Tyrell?
That's right.
But we can do the TRAS right now.
Yasha, if I don't take him into custody now, I'm telling him it's okay for him to do cocaine and that he's just gonna walk out of here. You think he'll ever stop? Really?
You can test him on Monday again.
He was out free and clear. He had the opportunity not to do it. He had the opportunity to clean himself. The only reason he's telling me now he wants to clean himself is because he's going in. That's the only reason, Yasha. Mr. Terrell, if you think that you're going to use cocaine and that you're going to walk out of here, it's just not going to happen. Goes with you.
chance, please.
I already gave you a chance.
I'm a child, sir. I have just like one more
Then
chance.
if you're using cocaine out in the free world, you have no business having a child with you.
Do you think you could give me one more chance?
No, he goes with you. Sorry, Mr. Terrell. It's not gonna happen. Sorry. I can't let him go, man. I can't. I know, and I'm gonna give it to him now. You are Jasmine Bautista. Ms. Bautista, you're charged with 2 cases. You're charged with assault of a family member. You're also charged with terroristic threat of a family or household member. On both of those, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews of the state of Texas. If you cannot afford a lawyer will be appointed to represent you. Okay.
Officer conducted follow-up investigation at 1505 Serpentine Drive, San Jacinto City in Harris County, Texas. Officer traveled to the residence and observed approximately a couple bullet holes, and the complaining witness advised that on August 25th at approximately 1:40 a.m., a dark-colored Dodge vehicle opened fire on the residence. No injuries were sustained. Complainant 1 advised that her brother's wife, later identified as the defendant, had recently made threats against the family. The complainant advised that her brother, complainant 2, and defendant had a fight on August 18th that escalated into a physical altercation. The complainant and other family members tried to separate them, and the defendant threatened to kill the entire family. Defendant threatened to have her brothers come and shoot all of them. The complainant, the defendant's husband, told officers that during the argument on August 18th, the defendant attacked him. Complainant advised that this was when the defendant threatened to have her brothers shoot and kill the entire family. Complainant believed the threat and fears for his life and his family's safety. Officer was given a video of the incident showing the defendant grabbing onto the complainant's leg and yelling, "You're all going to die, bitch, you and your fucking kids."
That statement, "you're gonna die," say that last statement again?
"You're all going to die, bitch, you and your fucking kids."
You, meaning the
Meaning the,
complaining witness, which is,
I believe, it was the defendant.
Zamaripa?
I believe. Because there's two complaining witnesses. There's the defendant's husband and then the defendant's husband's brother or sister, my apologies.
Okay, so it's a sister-in-law. So Ivan is the husband. Are you currently married to this person? Okay. Did I hear you say anything about the assault? What did you say about the assault? No, you were, that was just the terroristic threat.
In there, it says that there was a video of the defendant grabbing the complainant's leg. And then and there was also a physical altercation that they had to get involved in, separate them.
Okay, well, tell me about the assault. There has to be some kind of,
Can I have a response when he's done with that, yeah?
absolutely.
Let me see if I can find the OR, Your Honor.
Sure. Yeah, I have here, it says, on August 18th, 2024, the defendant, Jasmine Bautista, and the complainant were arguing and they were physically fighting. Raquel Zamaripa stated she saw the defendant scratching her brother. Raquel stated that she got involved to try to stop them from arguing and fighting, and that is when the defendant began screaming threats to her. The complainant and the other household members that she was going to have them all killed. The complainant statement, she believed the defendant could and would perform these threats.
Yes, Your Honor, there's that, and then when she grabbed the complainant's leg. So there's that first physical altercation where they had to intervene, as well as whenever she grabbed the complainant's leg.
Okay, so let me just read this to you so that you also get this. It says, affiant spoke with Ivan Zamaripa, the complainant, on or about August 29th, 2024. At the Jacinto City Police Department, Ivan stated that he has dated and lives with the defendant, Jasmine, for about a year. He stated that on August 18th, he was having a verbal argument with the defendant as she did not want him spending so much time with his family members, and that the defendant hit him and scratched him and bit him. Complainant stated a couple of his family or household members began to try to separate the defendant from him. As this was going on, the defendant screamed that she was going to have her brothers come to the residence and shoot all of them and that they were all going to die. Complainant stated the defendant also stated she said they were all going to die, even their kids. Complainant stated that he took the threat seriously and was in fear of his family's life. And as of the date his residence received gunshots on August 25th, 2024, he is in fear of his own serious imminent bodily injury. Complainant stated the defendant caused him and his family members to be in fear of their lives and serious imminent bodily injury. Complainant stated the defendant's assaults caused him pain and injuries. He showed photographs of his injuries from the night of August 18th, 2024. Affiant notes there were several fresh scratch marks on the complainant's back, chest, face, arm, and eye. Affiant also saw 3 fresh bite marks on the complainant. Complainant showed affiant of the incident where the defendant is holding on to the complainant's leg while she is sitting on the ground, and the complainant is trying to get away, and I heard her screaming, you're all going to die, fuck your kids. Affiant looked up defendant's driver's license number, yada, yada, compared it to the video, and positively identified the defendant as Jasmine Bautista.
Yes.
What do you got?
Your Honor, the very same day that this happened, she went to the hospital for her injuries that were caused during this incident. She filed an assault charge. I think it's one of those situations where they file first. I have tons of pictures showing injuries all over her body. There were 6 people, family members of the defendant, that attacked my client at the house. They all attacked her, even the complaining witness on the assault here. Your Honor, if she grabbed her leg, I don't hear any statement that it caused her pain or anything to that degree that would make it a Class A misdemeanor. It seems
Here it
like it would have been
says-
appropriately filed as a Class C.
No, I mean, it says here, where it says,
This is the collision between addiction and accountability. Legally, testing positive while on bond is a violation, period. The judge isn't punishing addiction. He's responding to a breach of court-ordered conditions. But here's the emotional layer. The defense is asking for treatment instead of jail. So, what actually works better? Immediate custody to force structure, or another shot at voluntary rehab?
good morning, Mr. Lee. Sir, you were charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 5th, 2025, the officer was conducting surveillance as part of a traffic crimes task force of motor vehicles racing westbound on Grand Parkway. And the officer observed the defendant's vehicle traveling in lane 2 and another vehicle in lane 1. The motor vehicle slowed down to approximately 30 miles per hour before launching at the same time in a competitive manner, accelerating to well over 110 to 125 miles per hour in an attempt to outpace each other. The motor vehicles raced 3 times, then pulled into a Buc-ee's. The officer observed the defendant, but was unable to locate the other motor vehicle involved in the race.
So then it says that also he picked up a felony evading. He was on bond for a felony evading and now he's picked up this case, a racing?
It looks like that's the case, Your Honor. He was on bond for the evading.
I'm taking away your privilege to drive. You are not allowed to drive, Mr. Lee. Do you understand? You will be signing an affidavit with me today promising me you're not going to drive. I don't give a rat's behind what is going on in your life. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. This is an affidavit that you're going to promise me that you're not going to drive. Do you understand? There's a burning building with 50 kids in it. I don't care. Do not drive. You mind filing those conditions as well, please? No driving.
No driving. Yes, Judge.
Have a lawyer. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Johnson. He will tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, you pick up another case, I'm going to revoke it. And if I find that you're a danger to the public, I'm going to make it sky high. I will do everything in my power to protect my public at all costs. Do you understand? You want the same day as the felony? Yeah? Okay. All right, guys. I'm going to have you sign a reset. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it. And then after that, you'll be free to go. All right. Thanks, guys.
The felony is all the way in June 2nd.
2026, Your Honor.
Is it set for trial or something?
No, he was on that's a placeholder setting because it was a PTI.
What's going to happen with that? Is he still in the PTI?
It was, from my understanding, I don't know. I think it was some conditions he had to do and he's almost done with it. So I think he's close. I don't know.
So is that, do you know whether they're going to keep him in that? Do they know about this?
I'm sure they know, but
Does the felony court?
I'm not attorney.
You're not the lawyer.
No, but they.
Okay. So let's just do this. Let's just do it right. We'll do a 30-day reset. And then I don't know what's going to happen upstairs. We'll see. You just keep us in the loop. Okay. All right. Good to see you.
Good to see you.
Next judge is page 10, Pace, come on up.
Good morning, Ms. Pace. Ma'am, you were charged with driving on a suspended license. You were facing up to 6 months in jail and or a $2,000 fine. We're going to do a probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 2nd, 2025, the officer observed the defendant's vehicle at the 900 block of Burke Road. He ran the license plate and it had a return of an expired registration as of November 2024. A traffic stop was conducted. The defendant was not able to provide a Texas driver's license, so instead the defendant provided a name and date of birth. The defendant stated she did not have financial responsibility on the vehicle, and the defendant was shown to have a suspended driver's license not eligible with multiple Class C warrants.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with the case.
Can I say something?
Please don't. You have the right to remain silent. Exercise that right. Do you have the ability to hire a lawyer?
Yes, I do.
You don't want a court-appointed lawyer?
No, I don't.
Okay, so we'll give you time to go hire a lawyer. I am making it a condition of your bond that you're not to drive unless you have a valid Texas driver license and liability insurance. And I'm going to have you sign a promise with me today. Doesn't matter what's going on in your life. If you want to drive, go get a license, get liability insurance. If you can show me that, I'll take this restriction off happily. Okay? Bless you. Did you sneeze?
No.
Just sneeze. Okay, man. So I'll have you sign this reset. I'll have you get with Victoria for a reset and then we'll get you out of here, man. Okay? Thank you.
All right, Judge, next is page 11. Reyes, come on up.
Good morning, Mr. Reyes. Sir, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 2nd, 2025, the officer was riding with HPD Traffic Crimes Task Force and a group of vehicles was meeting at 430 West Parker Road in Harris County, Texas. The officer observed the defendant, who was 18, brandish a firearm while walking around his vehicle. And the defendant exited from the motor vehicle on the driver's side, walked around the motor vehicle while brandishing the handgun, and then sat in the front passenger side seat. A traffic stop was initiated and the officer made contact with the defendant, the passenger of the vehicle, and the defendant admitted to carrying around a handgun, which was found under the passenger seat in the motor vehicle where the defendant was sitting.
Mr. Reyes, I'm going to find that there's probable cause to go forward with the case. What are you doing with yourself these days? Are you in school? You graduated from high school? Okay. I'm ordering you as a condition of your bond not to be in possession of weapons. You are not allowed to have a weapon. Do you understand? If I find that you have a weapon and you pick up a new case, I'm going to revoke your bond. I will put you in jail. Do you understand? Tell me, you want a lawyer?
I'm hiring one.
You don't want a court-appointed one? You do one? Okay. I just fill out an application. Let me see if I have an application on file. I need you to fill out an application for me. Let me take a look at it and then I'll appoint you one here in a bit. All right? Come on. Do you mind, Ms. Brown, giving him an application?
All right, Judge, next arraignment is page 13.
Can you
Scott,
file?
come on up.
Yes, Judge.
Counsel, do you have an arraignment?
No, approaching for bond violation.
All right, we're doing the.
Bear with me. I think we're close.
I have one.
Are you Mr. Scott? Mr. Scott, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 4th, 2025, in Harris County, Texas, the officer was dispatched to an assault. The officer met with the complainant who stated that the defendant and her had been in a sexual relationship, and she confronted the defendant about sleeping with another woman. The defendant became angry and followed her to a gas station where he pushed her to the ground with both hands, causing pain.
Okay, Mr. Scott, I'm going to find that there's probable cause to go forward with your case. Do we know, have you spoken to her to find out what she wants? Does she want to have contact with him? Does she not want to have contact with him?
Your Honor, we have not reached out at this time.
Okay.
Well, Judge,
Hold on a second. Just don't say anything at this point. I've got a bunch of DAs here. Whatever you say, they can use against you. I can give you a lawyer today if you want one. You know, you can give your side to the lawyer. The lawyers can talk to the DAs, but I don't want you to say anything to make the case any worse. All right. Because I don't know what she wants, I'm ordering you not to have any contact with her, not to be in possession of any weapons. I'm also entering what's called a magistrate order for emergency protection that identifies Ms. Walton as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate any threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Judge, you know the property that she lives, I paid for and proved out on another stadium around and get the homeless, right?
Let's do this. Let me give you a lawyer today. I can have them reach out to find out where she lives, what the address is. I just don't want you to have contact with her. I don't want you to go where she lives or where she works. That's it. Okay? I don't know. Let's do this. Let me give you a lawyer and we'll go from there. Okay? Do not leave until you sign our bond conditions though. Sorry?
Thanks for respecting now my kids, if you're represented to prove the court 1990.
So hang tight with me. We'll help you out. Don't worry. Okay? Please.
All right, Judge. Next
Yeah, I want to
is
do the loan.
page 5,
This is Scott.
Gutierrez, Angel.
Top of page 13. Can you, hey,
All
no
right,
contact
Judge,
with
that was
weapons.
the last one for now. Counsel, you may approach
So that was the last one.
for now.
No Spanish? No.
No.
Wow. Okay. Hi.
Aaron Durden.
Okay. Come up, Mr. Durden.
Mr. Durden was placed on bond conditions in November, toward the end of November, got an interlock at the end of November. His very first date to go have it recalibrated was at 12/29. He was out of town on that date, didn't get back until the next week when he was locked out. I got an email on Monday from the pretrial officer saying that he was locked out and notified you as well. He went the very next day, got it fixed, but you asked us to come here today to address it. He now understands.
I'm not going to play this game with you. Court orders are court orders. You have to follow them. And when you don't, there's severe consequence. And the consequence is you end up in jail. So I'm going to give you a pass now. But if it continues to happen, it's just not going to go well for you. Do you understand?
Yes, sir.
Okay. All right. That's it.
Is there a date that we have for the training still on? Thank you. I'll do that.
You ready? Hi. Who do you have?
Mr. Kabir, K-A-B-I-R. He was here for a bond violation because of a lockout, Your Honor. He since remedied that. Apparently his car battery
Do
shuts
you
off.
mind bringing him up?
Unconditional, yeah.
Yeah. Nothing.
Between them and the state, you know.
I'm not going to play this game with you, Mr. Kabir. If this continues to happen, it shows me that you're just don't care about the bond conditions and their severe consequences. Do you understand?
Your Honor, I don't drive this
I'm
vehicle.
I don't want you to, I'm just telling you, I have bond conditions in place and I expect for you to live up to them. And when you don't, there are severe consequences. Do you understand? Okay. You guys didn't want to add anything? Or did you have something to add? No?
Oh, Your Honor. No, that was it. That was the only reason.
Okay. All right, man.
Thank you.
Okay, bear with me. We'll do it.
Judge, that was continued supervision?
Yeah. Hi.
I was just gonna ask if you could sign something in your queue for Juarez Chavez.
Yeah.
Oh, great, sorry, thanks.
Just kidding.
She wanted us to know.
Hey, I don't have it. I don't have it.
Good morning, Judge. May I approach?
Yes, ma'am.
I'm here on an arraignment. Barragan, B-A-R.
I'm ready when you are. You might bring them up?
Yes.
Good morning, Mr. Barragan. You were charged with racing on a highway. You were facing up to a year in jail. I'm sorry, up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 5th, 2025, the officer was part of a street racing and takeover task force and was advised of a group that met at a gas station parking lot in the city limits of Harris County, Texas. The officer was working in a plainclothes capacity and was following the group from one location to another and viewed two vehicles race side by side at Highway 290 and Kickapoo Road, traveling westbound. The officer observed the defendant's vehicle and another vehicle slow down to approximately 50 miles per hour before launching at the same time in a competitive manner, accelerating well over 100 miles per hour in an attempt to outpace one another. The officer maintained visual and was able to detain the defendant, the driver of the silver Nissan observed, but was unable to locate the other vehicle.
How fast are we talking over 100?
Let me see if he specified, if it was just that.
Street racing pops up again here, and that's not a coincidence. Many cities now have dedicated task forces specifically targeting street racing and takeover events because speeds like 100 miles per hour or more turn a traffic offense into something much more serious. From a legal perspective, prosecutors often argue that this kind of behavior shows reckless disregard for public safety. And that's why even a misdemeanor racing charge can carry real jail time.
The officer only said well over 100. He didn't specify.
Barragan, I'm ordering you as a condition of your bond not to participate in this kind of activity again. If I find that you're racing, if I find that you participate in any kind of street takeovers, anything of this nature, reckless driving, donuts, whatever, I will take your ability to drive away from you. Do you understand? Not only that, it is a condition of your bond, and if I find that you do, I can revoke your bond and put you in jail. Can you file those conditions, please?
Yes, Judge.
You're going to reset your case to give you time to fight this thing. I'm going to have you sign a reset of victory. I'm going to have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it. And then after that, you'll be free to go. You have a lawyer. Because you do, I will waive your appearance, but it is your responsibility to stay in touch with her. If she tells you she can't get a hold of you because you're playing games, you pick up a new case, you've become a danger to my community, I will put you in jail. You understand? Okay, come on. Thank you.
Judge, I didn't hear, so PC was found, were there state's bond conditions?
States conditions, yeah.
State's bond conditions?
Yeah.
Okay, got it. Also, there was one more, sorry, off docket arraignment that was coordination consent over here. So whenever you're ready, on that.
Okay, who is it?
It's a printout up there, last Worthy.
Emmanuel Worthy, come up. Did you get the cause number for this?
Yes, Judge.
He's on probation. Has a motion been filed? I don't know, because the bond's still set at $100, so I don't know if a motion's been filed. Mr. Worthy, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 8th, 2025, the officer responded to a DPS agent who stated he was following the defendant's vehicle and needed assistance on the traffic stop, as the DPS agent was conducting surveillance on an unrelated case. The DPS agent provided a description of the defendant's vehicle, and the officer observed the defendant's vehicle failing to signal a lane change, along with the defendant's third brake light being out. The traffic stop was then conducted, and the officer made contact with the defendant. The officer observed a strong odor of marijuana, and the defendant was asked to step out of the vehicle, and the defendant stated there was nothing illegal inside. The officer located a cigar filled with a green leafy substance known to be marijuana based on training experience, with a weight of 0.09 grams or 0.032 ounces. A PC search of the vehicle was conducted, and the officer located an unholstered black handgun inside a backpack in the back seat of the vehicle.
Mr. Worthy, I'm going to find that there's probable cause to go forward with the case. Take a seat for me in the jury box. Okay, come on.
Morning, Judge.
Hey.
Judge, I have a quick question. I have Jonathan Guidry Joyal popped up on my docket. The only issue, I would like to hear PC, the only issue is he's in processing. I don't know if you want to wait till he pops up, or can we hear PC?
Yeah, we can hear PC, of course.
Yes, Judge.
You don't think there's PC?
I think there's two main issues that I'd like for you to hear.
It's on the jail docket, unlawful camera. Okay, go ahead, Judge.
On January 8th, 2025, the officer observed the defendant's motor vehicle fail to signal for 100 feet prior to making a lane change twice, from lane 3 to 2 and then from lane 2 to 1 on East Tex Freeway in Harris County, Texas. A traffic stop was initiated, and the officer observed further movements between the occupants of the vehicle before the driver, defendant Price, age 19, rolled down the windows of the motor vehicle. The officer approached the motor vehicle and observed a clear plastic bag with green liquid in plain view in the driver handle, believed to be promethazine based on training experience, and a bag with marijuana in the driver door pocket. The weight of the marijuana was 0.82 grams, and the promethazine was 101 grams. The officer observed an AR pistol in plain view on the rear left floorboard or left rear passenger seat, where the defendant, Guidry Royale, was seated. Guidry Royale, age 19, and a PC search on the motor vehicle was conducted, and the officer observed another AR pistol inside a black backpack in the right rear passenger seat where the defendant Kinnan was seated, along with defendant Kinnan's cell phone. The officer observed an unholstered Glock in plain view adjacent to the first AR pistol on the floorboard behind the driver's seat. The defendant, Guidry Royale, stated the firearms were passed from the front to the rear of the motor vehicle, but would not state who handed him the firearms.
If I may, Judge, hear the issue. So some stuff that's not there is that they were looking at this vehicle beforehand. This is
Remember, this is a probable cause hearing. I mean, I can't get into like,
right.
You know,
It's a suppression team. They're looking, they're following. It's a contextual stop. They're following them, waiting for a reason to stop them. The reason that they give is didn't signal for 100 feet. Sounds like they're on the highway. Okay. It's a conclusory statement. They're not stating that anybody else was in danger. They make no mention of.
well, failing to signal a lane change is a good, I mean, that's a traffic violation, is it not?
Well, 100 feet. They don't say at what point he failed to signal, whether or not he signaled at all, whether or not he signaled under 100 feet. They don't state at what foot or feet he did signal. It's conclusory. They don't give articulable facts regarding that. And so because it's conclusory and we don't.
I don't know. I think that there's enough probable cause to go.
Here's the second issue, Judge. The second issue is in the DIMS, this officer is stating that my client says they passed the gun to him and they handed the gun to him. That's what the DIMS says. But the OR says that my client says he doesn't know who tossed them from the front to the back. He doesn't say they handed it to him. He doesn't say they passed it to him.
But there was also an AR on the floorboard where he's sitting.
Right.
Right?
He says that they're not his. There's 4 people in the car. There's 4 people in the car. And only 3 out of 4 get charged with an unlawful carry of a weapon. He doesn't say, hey, they handed it to me. Hey, they passed it to me. What he says specifically is doesn't know who tossed them from the front to the back. This correlates to the furtive movements that the officer is talking about. He never claims possession of these guns. The guns are all in the car. He says they're not his, says the guns are not his, but he gets charged for the UCW.
And we're supposed to just take it, then just believe his, right?
Your Honor, if I may, and that's why, because they were found in the area where he was seated, the AR pistol, and he is underage at the time. That's the reason why he was charged, because he had them in his immediate proximity in the vehicle.
Yeah, I think that there's enough. Sorry?
It would be a question of fact, Judge.
Okay,
I think that there's enough, sorry.
okay, understood, Judge. Thank you, Judge.
Thank you, Ricardo. Mr. Doyle, you ready?
Sure.
Mr. Kim?
Hello.
Happy
Judge.
Friday.
Happy Friday.
Happy Friday.
I'm here on Mr. Reader.
Reader, yep.
He's finally here today.
Do you mind bringing him out? What's new? Everything all good?
Just, kicking off the new year. Kid stuff. How about you?
Same thing. My life revolves around kids,
My son still won't wear long pants, he'll still wear shorts.
In this weather? Are you?
That's a thing.
My daughter wears them fine, but yeah, my son just refuses.
How old is
to wear. He's 8, so.
It's 8.
Just doesn't care. He'll freeze to death before he admits.
Hopefully he's wearing a jacket and a sweater. I
Looks comical. Yeah.
I love shorts as well, and I hate wearing pants too, so.
That was after.
Are you opposed?
So I'm not opposed to a bond, I'm just opposed to a low bond. And so council has shared some more information regarding, because we haven't been getting, it's another one of those, we can't get a hold of the people from the demanding jurisdiction. It's one of those, because it's a 2B warrant, it hasn't been assigned to a prosecutor yet. And so we were trying to get a hold of the actual investigator for this charge. And Amy and I got shuffled around a little bit, so we could only speak with the extradition investigator, but we couldn't speak with the original investigator. So my facts are very, very limited. We don't.
I'm happy to give you some background, Judge. Mr. Reader, military veteran, was a medic in the Pacific, in Korea, meritorious awards, done well. When he finished with the military, the Army, lived in Georgia, then was hired over here by a very reputable hospital and medical center. He's the lead administrator. He was referred to me by the chief neurologist of this hospital. What ends up happening, he is in a custody dispute, and I believe Judge Kirby's, is that the judge, over in family court?
Here or over there?
Here. As this custody dispute sort of soured for his future ex-wife, he shows up at his hospital to go to work and is sworn and arrested on a warrant that he had no idea about. Apparently, this is some allegation that occurred in Georgia in June of 23. No report was made at the time. I think the state will confirm that. It wasn't until the custody issue here started to go south for his future ex. She then makes an online report in DeKalb County, Georgia, who accept charges without ever even talking to him, getting his side of the story. There's actual video evidence, I'm told, of what happened that's been litigated in family court. They're not responding to the state. All we want is a low bond so he can go deal with this there. He's not a flight risk. He's not family here. He's obviously got a good job. His boss is the one who brought me in on this. And so, I don't want to ask for $1 bond, but I ask as low as the court wants to go because it is a cash bond, and he's going to have to go hire a lawyer to deal with this.
So you're not going to go represent him over there?
I'm not. Well, I'm going to get it. I know. I stay in my lane.
Got it.
We're going to find somebody in DeKalb County that'll make this go away.
So, Mr. Reader, you are wanted out of the state of Georgia for aggravated assault and cruelty to a child. What we have here is, I don't know you. I've never met you before, but my main concern are 2. Are you a danger to my community? And number 2, most importantly, are you going to go back to Georgia? I have to make the bond sufficiently high if I give you a bond so that you're going to go back, because you are, as everyone, it's an inherent flight risk because you're a fugitive from another state.
Judge, if I could, one other thing, the aggravated assault, my understanding in Georgia is the impeding breath statute here. And the child part of it is, the allegation is the 12-year-old child witnessed this. So it's not, there's no weapon involved or anything like that. It's a simple domestic violence situation.
Any prior criminal history?
No, he has no other history, Judge. And so I'm not able to confirm, but that seems logical in terms of when the warrant was dropped, but it is correct. The charges, the Texas equivalent would be impeding breath, and I guess, I don't even know if we have.
You don't know this with certainty that
Oh, no,
that's
for the
what,
charges it is, but for the date, I don't have any other information. Like I said,
I don't know the actual, what the facts, what.
Oh, yes, the strength.
Impeding breath, or whether it's a
Impeding breath
shooting a
and-
gun.
And then cruelty to, it's strangulation, and the cruelty to child is the fact that the 12-year-old witnessed him allegedly strangling his wife. So, but regarding that, because of the nature of the charge, it's that state requests a $10,000 bond. And so.
You're okay with the
With
bond?
a
being
bond
set?
being set, because he has no prior other criminal history, he hasn't exhibited any other information I could find that he's a flight risk, so.
Okay. So state wants a $10,000 bond. What's your counter?
My counter would be 1,000, Judge. He's not going anywhere. He's got a good job here. He's got support here. I'm here. They're not bringing me here to run away from anything. We're gonna go fight this case and clear his name. Everything's here.
You got to understand that, if I set you a bond, we expect you to follow through, and there are very serious consequences. You're old enough to know that actions have serious consequences. And if you fail to act, I'm going to set you a bond, and we give you 14 days from the date of your release to go turn yourself into Georgia. If you fail to do that, I'm telling you now, I'm not going to play this game with you again. If you fail to go, I will issue a nationwide warrant for your arrest, and I'm going to set your bond at 0. You won't get another one. Do you understand?
Yes, Your Honor.
I don't know. So he wants 10, you want 1,000. I'll set it at 5,
Would you consider 2,500? Because my understanding, it's a cash bond. So we have to pay, we can't get a bondsman in here, pay the 10%. And he's gonna need money.
I defer to the court. Sorry, I was working on the waiver withdrawal form because he waived in magistrate court, so I'm just working on the waiver withdrawal right now. But I defer to the court. Because he doesn't have any other history, and because I'm limited information, it's hard for me to make any further assertions because no
To
one's
the
getting back
state's
to me.
credit, they've gone out of their way to reach out to Georgia, and and they're not responding. It's not.
He's great.
Lack of diligence on their part. But apparently, DeKalb County doesn't find this as much of a priority to respond to them, and they've had 2 days while he's been sitting in jail.
Okay, I'll acquiesce to the 2,500.
Thank you, Your Honor.
Moment, I have one form. Sign them all. Give me like 5 minutes.
The only other thing that I'm going to counsel you is that you got to be careful, man. What you do impacts everyone around you, especially a child. Hell hath no fury like a woman scorned and a teenager out of control, because the teenager that's out of control can make your life a living hell. And when they see that kind of, it impacts everyone. And I'm telling you, it reverberates, and it can just, like an infection, just grow out of control. 90% of the people in there now, no self-control. They get upset, they wig out, and they just go without thinking, hey, if I do this, what's gonna happen? If I say this, what's gonna happen? Just patience really goes a long way, All right, I'll set the bond at 2,500. Just be careful, man. All right? Okay, Mr. Doyle.
Thank you, Your Honor. Now,
Thank you, Judge.
excuse.
Yes, sir. I'm gonna have to, hold on a second. Hi.
Hi, good morning, Your Honor. I'm approaching on last name Moore, first name is Sheena.
Okay.
It's of a bond violation.
More, come up. Please show up for the drug test. We're not asking for much. I'm gonna send you for a test now. If you fail it again, it's not gonna go well for you, okay? All right, we'll send her for a test now. Assuming everything's okay, we'll just give you normal reset, but please, no more. All right? Okay, good luck, man. Give me a second, guys. When you're cool, the sun shines on you indoors.
Well,
No?
it's because really in some pinch is blinding me. So,
How are you?
it may be that coat.
That's what it is.
I'm good, Judge.
Mr. Coyne.
Angel Gutierrez, it's a DWI. I understand that you might want to talk about bond conditions.
Is this a new case?
Yes, it is.
Judge, this is for arraignment, he was in felony court.
All right, Mr. Gutierrez, come up.
Page 5.
I take it you are also representing him upstairs.
I am, Your Honor.
Wonderful.
Oh, sure.
Mr. Gutierrez, you were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 4th, 2025, at approximately 12:58 a.m., the officer observed the defendant's vehicle with no expired registration as of July 2024. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle. The window was not completely rolled down and the officer observed slurred speech and all further discovered the defendant had an open warrant and asked the defendant to step out of the vehicle. The officer observed an odor of alcoholic beverage and bloodshot eyes, and the officer did search of the defendant and found a marijuana blunt in the defendant's front pocket. The defendant stated he was coming from a bar and was driving home, and the defendant stated he had 1 cocktail drink and 2 shots. The defendant admitted to smoking the marijuana before going to the bar in the car, and the defendant stated he was 3 out of 10 drunk when asked to rate his intoxication. The defendant refused to send a field sobriety test, and the DIC was read to the defendant, who refused to provide a breath sample. A blood search warrant was signed and executed.
Mr. Gutierrez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. No more PR bonds. Do you understand?
Sir.
He has a prior FSRA and he's on bond for that case. Has anything happened to that because of the
I
DWI?
just signed on to that case. He was just recently arrested for it. We're in the beginning stages of
Is it a 2B?
It was. We're in the beginning stages of discovery, Judge. I know almost nothing about that case yet.
Was there a dead body?
No, Your Honor. It was a minor injury.
Great.
Yes, Your Honor, this is a leg injury.
On the FSRA?
On the FSRA, yes.
Okay. All right. Does he have a Texas driver license?
It's eligible, Your Honor.
All right. You are not allowed to drive unless you also have liability insurance. If you don't have liability insurance with your Texas driver license, you're not allowed to drive. If I find that you're driving also without insurance, I'm going to revoke your bond. Do you understand? All right. Now, you got a great lawyer. It's your responsibility to listen to Mr. Coyne, and he'll tell you when you have to come back to court. If he tells me that you're playing games, you're not responding to phone calls or text messages, I will issue a warrant for your arrest. Don't pick up a third case. 3 strikes. You know what happens, right? All right. Come on. Thank you.
Judge.
He's going to have to get with Felicia for bond conditions. We'll have him sign a reset, and then you're good to go.
Thank you. Thank you, Judge.
This way.
Yes, sir.
Cataract. I had surgery, so
Always a pleasure.
I wouldn't be disrespectful to the
I trust you. It doesn't matter. Mr. McAllister, I heard the wonderful news.
Yes, Judge, and I actually hear about that, just in administrative stuff. I was hoping you'd sign the motion to substitute to free up Peyton. Did you, on a certain cause number?
Are you now inheriting hundreds of cases or what?
This one, yes. And this one in particular is just one of those, that they're on PTI and they have a setting next year, but we got to free him up because he's getting sworn in on Monday, so.
Tell him congratulations from me, will you? You know, that's great.
Yeah, but we're all scrambling just to.
I can't even imagine, you know.
Change the name of the website. There's some administrative stuff going on, but.
I got it. I'll sign it for you.
You sign it for?
Yeah, of course.
Yeah. Okay.
Just let them know.
I'll let them know the cost.
I think I may have already signed it. Actually, it's a motion to sub.
Yes. You signed it.
You signed it? You already did it, Judge. Sorry, before I left the courthouse, I told him.
You're okay?
Thank you, Judge.
Take care. John D.
Judge, this is Ms. Prince.
All right. Good morning, Ms. Prince.
Morning.
Mr. Prince, you were charged with false report to a police officer. You were facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 5 days in jail with credit for the 5 days that you've done. You need to understand that by pleading guilty, this charge is going to go on your record. It's going to be there for the rest of your life. From now on, you'll be facing a minimum of 90 days in jail. Do you understand?
Yes, sir.
You were giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, you can never change this or undo this.
Yes, sir.
How do you plead to the offense, ma'am?
Guilty.
I will find you guilty, sentence you to 5 days in jail, give you credit for the 5 days. The enhancement will be abandoned, and good luck to you.
Daryl Nabiyama, he's in custody. He was put out on bond for a felony and he picked up his DWI. So he's set for bond. Has the bond already been set for this one?
Let me see. Oh my goodness, 100,000 on the Agra, or on the Agra assault, huh?
Yeah, he doesn't think he can make it, so.
So what happened? He was out on bond for this?
Yes, well, I'm not over the felony, another attorney at the firm is, but yes, from my understanding, he was out on bond for the felony and then he picked up this DWI.
So they revoked it and raised it
Yeah,
to-
they revoked it and raised it, yeah.
Okay, whatever you want, you know.
Set it at 1,000.
Well, but the bond is set at 5,000.
Oh, it's already set?
Already made bond.
Okay.
So there's nothing really for us to do. Felony court is 116. You want to set it for the day after? Or do you want a longer reset?
A long reset, because I don't think it's gonna get some.
Okay, whatever you need.
Thank you, Judge.
Yes, ma'am. Thank you. So it looks like you have a fugitive case. Oh, you picked up 3 cases. You picked up a fraudulent use of ID, less than 5 items. You picked up a theft case, and you have an out-of-state fugitive case.
One of them has been dismissed, Judge. The fraudulent use of items has
Saw
been
that.
dismissed. So technically, he's only got the theft pending and the fugitive case pending.
Mr. Kim, enlighten us.
Your Honor, this defendant is wanted out of Broward County, Florida for felony theft. State would be opposed to a bond. There are 47 cycles of criminal history in the past 5 years alone, and these are just convictions.
47 pages of criminal history in 5 years?
47 cycles, Your Honor. For pages, it is 46 pages of criminal history, including, well, the California one's old, so I'm not gonna count that one, but just in the last 5 years alone, and these are just.
They were not 47 in the last 5 years.
Hey, don't talk. I mean, we're just trying to, you know, the thing is, Mr. Jones, is I have a very limited amount of time to try to get to know you. Everyone that comes in front of me tells me it's gumdrops and rainbows and little bunnies jumping in the woods. But the way I really get to know you is the paper, because that tells me who you are, right? If you're a dangerous person, if you're a person that I'm going to let go and you're going to continue with the criminality, I have enough trouble sleeping as it is. I don't want more blood on my hands. I don't want something else that's going to keep me up at night. So that's why. Well, but this is how we get to know you. And he's telling me you got 46 pages of criminal history.
Your Honor, in the past 2 years, he's had 3 failure to appears of multiple cases. He's had 2 habitation trespass convictions, a DWLI, prostitution, battery, criminal damage, failure to appear, possession of drugs, felony, obviously, resisting. But in the 21 some odd years, it's the 47 cycles of different offenses, and I just stopped scrolling after 2020.
How many failure to appears do we have?
3, Your Honor. And this one itself is a no-show, or according to the transmission.
Hey, Jan, could I say something?
Sure.
Okay, with the one he talking about with the failure to appear, I feel that was nonsense because of the simple fact that I flew from Fort Lauderdale up here after they said I had a warrant, and I went to court a couple days before that. And is that documented, sir? You can see that?
Judge, I will say this, he did explain that
How
to
old are you,
me.
Mr. Jones?
I'm 40 years old, sir.
You're 40.
Yes, sir.
How many cases has he picked up in total?
That he's been charged with. If you give me 10 minutes, I can count them, but it's not low. I mean, I can start from 2004.
So theoretically, for every year you've been born, you've had a case.
I have a
You're
question.
40 years old, and you
Sir.
have around 46 pages of criminal history. So literally for every year you've been born, you've like picked up a case. And not only that, you've got multiple failures to
Sometimes you don't think the jurisdiction will fail me?
Huh?
You don't think the jurisdiction will fail me?
But the problem is, at some point, your actions become your own. You now have with us, you've picked up a theft case here in Harris County. You've got an open case in another jurisdiction. You've got pages upon pages. So at what point is it on you?
When you pay your debt to society, why do they keep using it against you? I pay my debt to society for those.
Because it continues.
For those hires, okay.
Continues to happen. At some
Okay.
point, DAs are like, you know, jail just doesn't work anymore. So that's when we got to go to prison, because this dude.
But prison don't help guys. That don't make them better. That make them worse. Instead of tormenting them and sending them and feeding them to the wolves, y'all should sit down with that person to find out what's going on to help that person. Instead of prison not helping nobody, prison is not.
I can't tell you how many stories I have read of people who get degrees, college degrees, even become a lawyer while they're in prison. So if you want it to help, then it will. But you got to want it. If you
One better than me, Your Honor.
If you
But
have-
you know what the sad thing about it is, and in the state of Florida with me, and that's why I left. Something happened, and I have a conflict of interest against the police. So now they're jigging at me every chance that they get. But it's crazy. He's saying I have a warrant, and I flew from there after that warrant was pro se. Pro se that they said I have. I flew from Fort Lauderdale all the way to Houston, flew back down there, and flew back. And they said I have a warrant, and I flew and went to court for another charge down there.
I don't get it.
And I went inside.
I don't know how that happened, but it's not supposed to. You know,
So who's the system failing? If I have a warrant, you mean to tell me they're gonna let me in their courtroom, attend to my judge, see my judge, everything, and let me go, and let me get back on the plane to fly back here? Mind you, I flew from here and flew back down there. They let me do all of this with a warrant?
I can't explain that. I can't.
So that's the system failing somewhere, somehow. That's not me.
Let me talk to the judge real fast.
But Mr. Jones, if you have this woe is me attitude, it's never going to change. It's never going to change.
You're not helping. It's not helping. Y'all not helping society. Y'all always blaming me and this and that and the other. Prime example, he's saying, oh, he got prices from here. And he went to calling stuff off that he said, well, only stopping from 2022, and he going past 2022. And I'm like, yo, but hey, but that's what the prosecutor do. He just doing his job.
Right, that's what he's doing.
Judge, if I may, a couple points. First, you know, if he's finished up the cases that he has had in his history, he's had a history, okay, he's had a history. If he's paid his debt to society, like he says, if he's completed what he needs to do for those cases, that really shouldn't be relevant here. I would argue that in front of you, this is his first time being in front of you, right? And it looks bad that he has a criminal history. Yes, I get that. But if we were to just focus on whether or not he knew about this case, he's telling me he got on a flight, came over here, and it's a great question. If that happened, he would have had a warrant pending and he would have been arrested. So
When was the warrant issued, do you know?
March 3rd, 2025, but because it's a domestic flight, and obviously I don't work for TSA, I don't work for Department of Homeland Security.
Just got issued.
just March 3rd, 2025, Judge.
Your warrant was just issued in March of this year. So
And I flew
30 days ago, it got issued.
And I flew March 10th back up here
So Judge, if that's the case, it hasn't been like he's been missing his responsibilities with
And
this
I went to
case.
court.
It's
And you
less than a month.
And you can
that he's
also
had
see
this
that I
thing
went to
pending.
court. I went to court before March 3rd.
That's why it's a failure to appear, which is.
How? I went to court. I went to court before then.
Judge, the warrant has
I was
been
in the
issued
courtroom.
we're at April 1st, less than a month. And so it's not like he's been running. If the warrant's just been issued on March 3rd, I would ask that we afford this man an opportunity to make this right. He hasn't messed up in your eyes. Yeah, he's messed up in the past, but as far as the fugitive case is concerned, I'm asking for an opportunity for him to go to the demanding jurisdiction. And then if he messes up, okay, well, I don't have much to say after that. But just throwing his history out there, it doesn't mean he doesn't deserve a chance.
I stand by the no bond. He has assaultive history as well, and it shows in the message that we received from Florida is that he has violent tendencies, obviously reflected by the assaultive history, along with and I don't have to go ad nauseum, but the significant criminal history that he has.
When were the FTAs? How long ago?
The most recent failure to appears, one moment, Judge. There's one from May 4th, 2023. There's one from December 7th, 2023. There's one from.
But it's not on this case, though. Those are separate cases. We're not talking about on this case, are we?
To be clear, it's not on this case, but.
Obviously not on this case, but the problem is that it keeps happening, and I can't continue to.
Sir, it's not keep happening, sir. Sir, this warrant that he said, sir, I went to court. I'm gonna be honest with you. I have another open case, and that open case is why I flew back down there. Went to court, finished court. They said I have a warrant. I go to the warrant district. They said I have no warrant. Leave the warrant district, get on the plane to fly back up here. And they said I had a warrant before I even flew on the plane back down there. So how could I fly?
Mr. Jones, even if I were to set you a bond.
Okay, no problem. Hey, take me back there, man. Can't about this shit, man.
Easy money. There you go.
So for the second one, we're going to be, well, actually, it's going to be Ricardo's request, but.
Yeah, Judge, on the.
If you want me to take it off, I will.
Yeah, on the second one, let's take it off. I'm concerned about HIPAA stuff and.
Ask them to bring it up.
Yes, Judge.
Hey, you want to go through the list?
Yes, Judge. Oh, that's sorry. No, my person is,
Mr. Nelson has a warrant out of Florida. He did have a local case that was resolved this morning.
Just dismissed. Yeah, today.
Yeah, it was, actually, I think.
No, he pled. Right. Okay.
He pled on that. He previously had signed a waiver 7 days ago, I think, but
March
he-
31st. March 31st.
March 31st.
Oh, yesterday.
Last Friday. But anyway, his value of time is probably exaggerated. He has a warrant for Florida. He's been picked up on this before in Tennessee, and they didn't extradite him from Tennessee. They released him after 3 days. He's back in jail here in Texas now, obviously, for the same charge out of Florida, and he is a cancer patient, and he's wanting you to grant him a PR bond so he can go back to Florida.
That's where I was heading.
Really?
Yeah, it was.
Oh, it just so happened that you.
No, sir.
And you got a failure ID as well.
But the failure ID was, they pulled a gun on the guy they were looking for, and I was at the crosswalk. I wasn't there. They weren't stopping me. They stopped another guy. They were waiting for 3 days or whatever to get him. And then yes, sir.
It doesn't matter.
This is not our first time being here on this case, Amy,
He's previously had a fugitive case in Tennessee for this.
for this same charge.
Well, just a fugitive case in general. I can't say much.
So that was in Tennessee. Now he's one out of Florida.
No. He had this exact same proceeding in Tennessee.
Meaning he was a fugitive in Tennessee because of Florida.
Yes, he was incarcerated in Tennessee and had a hold on him from Florida. They chose not to extradite him at that particular time, and he was released 3 or 4 days there.
How long ago was that?
How long ago was that, sir?
5, 6 years ago.
And after 5 to 6 years ago, you still haven't taken care of the case.
That was during pre-COVID, and we were coming back from Michigan, and we were on our way down, and we stopped in Tennessee. I started working at the hotel. And they came in and they said, out of the clear blue, looks like you got a warrant. And I go, what? Okay, so they took me in, they ran everything, they held me for 3 days and they let me loose. They didn't, there was no new charges or nothing.
What's he wanted for?
It's domestic violence.
In Florida, he's wanted for a couple different warrants on bond revocation for domestic battery by strangulation, violation of pretrial for domestic battery, violation of pretrial for domestic battery by strangulation, failure to appear for domestic battery, strangulation, and grand theft.
That was back in
And it's been open for
12 years.
and you still won't go back?
No, we were gonna go back. That was the whole thing. I was in
The
Florida.
only thing I'm waiting for you to say is that you were abducted by aliens that prevented you from.
I'm not gonna lie to you, sir, but we were going back. When COVID hit, actually, I was in Florida. That's where we went from Michigan to Tennessee, then Tennessee down to Florida during the pre-COVID. And we were in, I think Pensacola. And we were there for like 3 months and we were waiting for the COVID to stop, but it just didn't end. So I ended up talking to a gentleman that had plenty of work for me across the country to go to all of his hotel properties to fix them and find out why they were failing, why were they not making any money and what was going on. So that's what I've been doing.
Does Florida really want him? Are they gonna come get him? Are we just playing games here? You know, because if they really want to get him, I'm gonna hold him. But if they're not gonna come get him, then I'm not gonna hold him. We have enough people in our jail as it is. So let's do this. The problem is, Mr. Nelson, you don't learn your lesson. You've repeatedly been arrested on this charge and they've told you to go back and you refuse to go back. So I can't, in good conscience, give you a bond when you refuse to comply with court orders.
I understand
You
that.
just don't want to do it. You want to do what you want to do. And then,
No.
hey, if I happen to get arrested, they're not going to come get me anyways. So
No, I don't say that at all.
you don't say it,
Right.
but your actions say
I
something
understand.
different.
I understand that. I do.
When people tell you stuff, it goes in this here, it goes in, what
I know.
matters are actions.
I understand.
So
With regards to Florida, I'm happy to check up on that. He does also have other warrants from other states. He has a probation violation from Michigan and also intimidation.
They're not
Scotching with states, man.
Oh, they already told the jail, they already made the call, they're not coming, they don't want nothing to do with me. That's already been
They don't
determined.
have a hold file right now, but he does have the other warrants.
And those are from 2009. And I served my time on all of it, but it's just,
So
I
let's do
understand.
this. Let's roll it to tomorrow. Please reach out to Florida and see, do you really want him? If you do, here he is. If not, can we, really?
We'll be back tomorrow.
thank you so much, Your Honor.
All right, Mr. Nelson.
Hey, I love your show.
I don't have a show.
I watch on.
I like you too.
Okay.
Superstar.
We are approaching on Mr. Avalar.
Thank you. Okay.
And I believe defense wanted to ask about bond conditions, Judge.
Yes, Your Honor. So yesterday, I believe you gave him a $5,000 bond. He picked up a new offense for violating bond conditions. Your Honor, it turns out that the facts are that he had stayed away, his, the woman who he was in this issue with, her house caught on fire, burned to the ground. She called him asking for assistance. He said, hey, I don't know. I don't think I can be talking to you. And then 2 days later, she got into a car accident where her vehicle was totaled. And she said, please, I have nowhere to go. Can you help? He said, look, I'll help you find some place to go and I'll drive you there. And that's it. In the midst of driving her there, he was pulled over for no registration.
Calls Murphy's Law is what it's
Yeah,
called.
and she said, I've got bad juju.
You know?
The state confirmed all this.
Yes, Judge, so
Go ahead and bring him out. Avalar.
Judge, the prosecutor on the case did call the complainant. She pretty much gave nearly the exact same story of her apartment burned down. She was just trying to get a ride. They have not had contact up until this point. So we are not ready to offer a plea today because it is a new case.
Sure.
But we are okay with the PR bond at this point, just given the circumstances and the facts.
What do we do about conditions?
Conditions, we would still like to keep that no contact in place. It seems like they didn't have an issue up until this point with it. So we would just reinstate that no contact.
I will ask for a short reset, Your Honor, but from speaking with the CW, She communicated to me that the whole thing was a misunderstanding. She feels safe around him, and honestly, she'd like for them to be able to have contact. The way she communicated to me, the initial situation was they were arguing, a police officer was coming by, so she flagged him down so she could stay away from him. And then while talking to the officer, she showed him, like, look at this message. He said he's gonna do this to me. But that's in the course of how they normally communicate to each other. And she didn't feel afraid. The officer just took it to that next
How
level.
about the assault we talking, happened in the assault?
So, Judge, I believe the case for us right now is a terroristic threat. So we're just looking at the terroristic threat
Morning.
charge.
How's jail?
Tiring.
Sucks, right? It's supposed to suck. That's what happens when you don't do what you're supposed to do. You can't do stuff on your own and think that good things are going to happen. It's what I was telling your lawyer. It's called Murphy's Law. What can happen will happen. I get that you may be trying to help someone, but a court order is a court order. And when you don't follow them, bad things happen. And that's why I'm saying, you know, I mean, maybe it's divine intervention that like you get pulled over right on the day that you're trying to do this. So really, now, both of them are in agreement for you to get a PR bond because really, it's not a capital case. But you have to understand that court orders are court orders and they're still there. If you want them taken off, if you want to do something different, you have a lawyer and you ask a lawyer to help you out. But you just can't do stuff on your own and expect good things to happen. Now, state is still asking for you not to have contact with this person and as of right now. So I'm going to give you a PR bond now because they're both in agreement. I'm telling you now, you do this again, you will not get another one. I promise you on everything that's holy. Do you understand? If you want something, ask. We can always address it. We can always fix it. Just don't do stuff on your own. That's when it goes sideways.
Sir.
Do you have any questions? Okay, so I'll grant you a PR bond. We need it on both cases, I think, right? So do you mind filing a new no contact order now? No weapons, no contact. Don't for the moment. Perhaps time will heal all wounds. Perhaps after some time, you know, after she speaks to the complaining witness, things can change. Just don't do it again. All right?
Judge, I believe there is a order for emergency protection in your queue. It was filed the 30th, so it should be in there. Do you want me to file another one?
It's 255-1405. That's the initial terroristic threat.
Yes, there was a protection order signed on February 13th.
And then
You okay with that?
he's made bond.
Okay, done.
Made bond on the BPO already.
Oh, right. So we'll just leave, and I didn't do anything to the VPO. So we'll just give a PR bond on the terroristic threat.
Reinstate the PR bond.
Yeah, I'm okay with that.
And so just a reinstatement on the.
Whatever's easier. Yeah.
Okay.
Are we good? Okay. Thank you. So hold on, let me take, okay, we're good. All right. Jason Fisher, right? Okay. So Mr. Fisher, you're charged with 2 cases. You're charged with driving while intoxicated. Second offense, you're also charged with failure to stop and give information. You have worked out an agreement where they're offering you 180 days in jail with 72 days credit on the DWI second, and they're going to dismiss, I would assume, the FSGI.
And there's a kind of felony that was keeping him in, it's keeping him in custody.
Got it. Is this what you want to do? You need to understand, Mr. Fisher, that from now on, if you pick up any more DWIs, you'll be looking at yet another felony. We're not asking for much, man. All we want our streets to be safe. Here, we have a second DWI and a crash. What's it going to take? Kill someone? You know? Do you want to end up with a 50-year sentence? Next time you ever get into a car and you get pulled over, all officers do is they look at your record, and that's all they care about. So if they pull you over, they see that DWI, FSGI, DWI, possession, and they come to you and they smell alcohol or dope. What do you think they're going to do? You think they're going to be nice? Probably not. Don't get into a car if you've had anything to drink. You understand? Are you sure?
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. This will go on your record. It's going to be there for the rest of your life. You can never take it off. Do you understand?
Yes, sir.
How do you plead to the offense of driving while intoxicated, second offense? I will find you guilty. I am going to suspend your license for 2 years. Do not drive until you get a license. Do you understand?
Yes.
All right, good luck. I don't know if you think that this is a joke, but you've been given a very, very generous program that if you complete successfully, they will dismiss this case. You have tested positive. Is it multiple occasions or just once? This is Mr.
I'm sorry.
Canales.
Oh, sorry.
That's okay. Mr. Torre, you're killing.
That's my fault.
He's tested positive.
How many times?
3 times.
That is unacceptable. And if it were me, we'd be done. They see fit to put you into an intensive outpatient treatment. You have 2 weeks to enroll. And I'm going to tell you right now, you ever test positive again, I'm going to immediately set your case for trial. You get no more resets. Do you understand?
Yes.
I want it tested 2 times a week for the remainder. Okay? You will now be tested every Monday and every Thursday for the remainder of this program. And if you use again, and I don't care what it is, and I don't care what your excuse is, you will be set for trial.
Okay.
Do you understand?
Yeah.
Okay?
Yes.
All right.
Thank you, Judge.
Is it okay if we test in the region or would you like?
No, I'm okay, of course. I don't care where, as long as he's doing it 2 times a week.
Okay.
Okay.
No, I got it.
Judge, we'll be bringing out Mr. Alexis Jones.
Okay. Come up. Good to see you.
I know, good to see you.
Been a while,
I
huh?
know.
We sent him for a test.
Yes.
Yes, judges presented for morphine.
Morphine.
Judge, he broke his arm and he's on Tylenol with codeine and he got out of the hospital March 28th and they had also given him stuff there. And we do have a prescription. So I don't want you to be upset about that. You can be upset about other things, but not that.
How long? Because they don't give that very much now at all, if ever. They give me these kind of. So I'm going to test you like crazy to ensure that you're not using. I'd like a copy of the prescription. I want to know how many pills there are so that we know how long he's taking it. Because if he's testing positive for weeks upon weeks, then it's unacceptable. If I find that you're using, if I find that you're using alcohol, if I find that you're a danger to my community, I only have one place for you. Do you understand? I will do everything in my power to protect my community at all costs. I don't care who you are. I don't care what color you are. Do you understand? So he gets tested weekly from now on so that we know how much he's using. You have a lawyer. It is your responsibility to stay in touch with her. If she tells me she can't get a hold of you because you're playing games or you pick up a new case, you're not allowed to drive. Do you understand? If I find that you drive, that would be the absolute worst, and you're looking at a possible contempt charge. You understand? Okay?
Judge, if I could ask one thing, I wasn't here for bond conditions and there's got an ankle monitor.
So, right. He was crammed, so he's not using alcohol. I put a GPS on him so he's not out in the middle of the night, because I don't want him out in the middle of the night as well.
Okay, so it was just he works at a mall and he sometimes closes at 9. So it's just 9 to 6. I was just saying, could we make it 10? Because if you close, okay. Okay, thank you. Okay, thank you, Judge.
Good luck. Ms. Burgos, you are charged with driving while intoxicated. You have worked out an agreement where they're offering you 45 days in jail with 15 days credit. You give up a lot of rights by entering into this agreement. You need to understand that after today, this charge will go on your record. It will be there for the rest of your life. If you ever get pulled over in a car and you smell like alcohol or dope, and an officer sees this, it's probably not going to go well for you. From now on, you are looking at a minimum of 30 days in jail for any new cases that you pick up. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, right to be arraigned, charged with in open court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty, you can never change this. Knowing all this, do you still want to do this?
Yes,
How do you plead to the driving while intoxicated? Guilty or not guilty?
guilty.
I'm going to find you guilty. I will follow the agreement. I'm going to suspend your ability to drive or your ability to get a license for 90 days. Do not drive until you get a license. Good luck to you, man. Thank you. Mr. Ruba, you were placed on probation for racing on a highway. It has now come to my attention that you have now violated this probation. Is it true or untrue?
Sure.
Okay, I'm now going to revoke your probation and reform the judgment. It will now reflect as a conviction on your record. The agreement is 30 days in jail with credit for the 1 day that you have done. I am allowing you to turn yourself in April 18th, 2025 by 6 p.m. If you fail to turn yourself in, we will have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. Do you understand? If you are someone who is perpetually late to everything, this is one of the worst things because if you arrive at 6:01, they will not take you and it will not go well for you. Do you understand?
Sir, I understand.
All right. So is it true or untrue that you violated your probation?
Sir, good.
It is true or untrue? It's true. All right. I'm going to find that it's true. Do you have a copy of the motion? Which one are we going with? Is it the one failure to do the effective decision making? I did so, Judge. Yeah, let's do the effective decision making. All right. All right. Mr. Rubio, I don't know if DPS is going to suspend your license. If you don't have a license, do not drive. If you don't have a license and liability, don't drive, because if you get into an accident and you maim someone, they're going to come after you for $50,000 to $100,000 and then you're going to be in the hole forever. You understand? All right, good luck.
Thank you, Judge.
Thank you.
Can I get him over here? Dave, can we get a nollie on that second case?
Yes, ma'am.
Good morning, Mr. Sheriff.
Morning, sir.
How's jail?
I don't like it.
You know, you failed to appear 2, if not 3 times for these cases. Listen,
Okay, I'm sorry.
all I'm trying to tell you is that when you appear for court, good things happen. We have such reasonable prosecutors here. All you have to do is show up, and 9 times out of 10, good things happen. But when you fail to appear repeatedly, you now are deemed a flight risk. This is what happens. You need to understand one more thing. As a result of what we're doing today, from now on, you are facing a minimum of 30 days in jail for any new cases that you pick up here. Do you understand?
Yes, sir.
You're charged with 2 cases. You're charged with terroristic threat of a family or household member. You're also charged with criminal mischief. The plea bargain agreement you have worked out, they're going to dismiss the criminal mischief. They're also going to reduce your terroristic threat to a Class B. So now you're facing only 180 days and or a $2,000 fine. $2,000 fine. You've worked out an agreement. They're offering you 13 days in jail with credit for the 13 days that you have done. By pleading guilty, like I said, this will reflect as a conviction. Do you understand?
Yes, sir.
You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, you can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this. Is this what you want to do?
Yes.
How do you plead to the terroristic threat? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to withhold, or I'm going to find you guilty, send you to the agreement. The only other thing I'm going to tell you is that whatever you did to pick up these cases, I would be very careful, because if you continue with the same course of conduct, it's very possible they charge you with a more serious offense. All right?
Yes, sir.
Good luck, sir. And next time, show up. All right.
Okay.
Good luck.
Take care. You are Javier Guevara.
Yes.
Mr. Guevara, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you have done. You need to understand that you're making a lifetime decision today where this DWI will be going on your record. It will be there for the rest of your life. It's even there after you die. This is important because if you get pulled over in the future, the first thing an officer does is they look at your record. And if they see that you have a prior DWI and they go to your window and they smell alcohol or they smell anything funky, it's probably not going to go well for you. And what we're doing today, from now on, you're facing a minimum of 30 days in jail. Do you understand?
Yes.
Even if you have a sip of alcohol, I wouldn't get into a car because it is a humongous risk. Giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible facing consequences. You can be deported, excluded from the country, denied naturalization under federal law, and you give up the right to appeal. That's why I said, once you plead guilty, it goes on your record, it will be there forever. Knowing all this, do you still want to do this?
Sabiendo todo, quiere seguirte. Viendo toda la información que le dio, pues, quiere seguir. Yes.
Speak to the offense of driving while intoxicated, guilty or not guilty.
Guilty.
One more thing you need to understand, Mr. Guevara. DWI is big business in Texas. There's a $3,000 surcharge that would normally apply to you now as a result of you pleading guilty. And if you don't pay it, every $100 you owe, you sit 1 day in jail. I will waive that for you now because we all make mistakes. But I'm telling you now, if you continue to make mistakes where you endanger my public, the next DWI, it is a $6,000 surcharge. And like I said, if you don't pay it, $100 that you owe, you sit 1 day in jail. Do you understand? If you want to get lit, take an Uber. I'm going to suspend your license for 90 days. Do not drive until you get a license. Good luck to you, Mr. Guevara. Starting with the state.
John Davenport, City, Your Honor. Jose Ceja for Mr. Alfaro.
Okay, are you in on this as well?
I'll tell you. Blake jurisdiction on behalf of the state of Texas, Your Honor.
Got it, okay. So for purposes of the record, we are here. Today is set for a dispositive motion to suppress on this DWI second. And we are all in agreement that it is a dispositive nature. So if state loses, you dismiss. If you lose, you end up pleading, correct?
Right, and I think we already have the plea worked out, which is a reduction to DWI first probation.
Okay.
And Your Honor, that was a prior deal for the prior prosecutor that I'm on.
You're okay with it?
I'm on.
Okay. You said you had some stipulations that you want to go over.
Yes, Mr. Davenport and I have some stipulations regarding to the relevant times, just to speed up the testimony.
Okay.
And I think he's got them written down. I'm not sure if he wants to read them into the record.
You mind?
Yes, sure.
Please.
At 3:40 a.m. on July 7th, the officers arrived on scene. At 3:44 a.m., the officers made contact with the defendant. At 3:46 a.m., the defendant was detained and placed in the officer's vehicle. And at 4:30, Officer Rohr begins the DWI investigation at the police station.
You said at the police station.
Yes, Your Honor.
So there's no investigation on the scene.
There is no DWI investigation on the scene.
Okay. So it's your motion.
I don't know if the state is stipulating that this was a warrantless arrest. I mean, if not, then I can just call the officers and establish that.
You don't stipulate that it was a warrantless arrest.
Okay. All right. Ready?
Yes, Your Honor.
Okay.
And
Floor is yours.
when if the state calls Chad Johnson to the scene.
Do you mind grabbing? Is he in the courtroom or is he outside? Please come up to the stand and raise your right hand to be sworn. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay? Please mind taking a seat. If you don't mind, please speak loudly, clearly. If you hear the word objection, just stop until it's addressed and then you may continue. Okay?
Yes.
Okay. Okay, the floor is yours.
Thank you. Can you please state your full name for the record?
Chad Johnston,
And what do you do for work?
employed by the Pasadena Police Department,
How long have you been doing that for?
6 years.
Do you have to have any specialized training and experience for that?
That's the police academy.
Can you kind of briefly describe what that training involves?
Police academy?
Yes, just
Penal code, transportation code, CCP, DWIs, traffic stop stack, building clearing. Basically anything that we could use on our job control.
And do you have any other experience prior to working at Pasadena Police Department?
In law
In law enforcement, yes.
Yeah.
And approximately how many DWI investigations have you done?
I'm sorry, repeat that.
Approximately how many DWI investigations have you been a part of in your career?
Hundreds.
And do you recall a particular DWI investigation you were a part of on July 7th, 2024?
Sir.
Specifically, how did you come to be involved in the incident we are here for today?
Our dispatch received a call for service while a subject passed out at a intersection on the way.
Can you clarify what you mean by pass out?
Subject was inside his vehicle in a medium lane travel, asleep at the driver's wheel.
And what did you see when you got there?
Once I got there, their vehicle in the number 2 lanes for eastbound traffic on Southmore, stopped. Driver was slumped over, asleep with loud music. We initially started with flashing our flashlights on him, banging on the window. That was unsuccessful. It got to the point where me and my backup officer began rocking the vehicle for several minutes before the defendant woke up.
And did these facts at the time, did they indicate or raise your suspicions as to any particular crime that might be occurring?
Possible, yeah.
Why is that?
I mean, normally people do not fall asleep at the wheel while driving a motor vehicle, especially with their foot on the brake and the vehicle still in drive. And then if someone does fall asleep, which has happened in the past, they usually wake up pretty easily and don't need officers rocking the vehicle from side to side in order to wake them up.
So you eventually woke up the defendant, correct?
Yes.
And what did you do after that?
Once I woke him up, he took his foot off the brake and rolled into my backup officer's marked patrol vehicle. Then once he was stopped in the patrol vehicle, he got him to open up the door. I turned the vehicle off and placed it in park, got him outside the vehicle.
And when you got him out of the vehicle, did you notice anything specifically about it?
I smelled a strong odor of alcoholic beverages emitting from his breath in person, and he had slurred speech.
And what did you do next?
I requested a DWI task force officer come to the scene if one was available.
And those signs that you said you observed when you made contact with the defendant, based on your training experience, what does that indicate to you?
Those are signs of intoxication.
You said you contacted a DWI officer, and after that, what did you do?
He was not available. He was occupied at the jail. Due to the vehicle being in moving line of travel, I arrested the driver for impeding the flow of traffic and transported them to the jail for the traffic offense and for the DWI officer to conduct a DWI investigation.
So you said earlier how many DWI investigations you've been a part of, but how many DWI investigations have you taken all the way through?
Very few. If I were to guess, probably less than 5.
And about how long would you say it takes you to complete a DWI investigation?
It would take me several hours.
And where was the scene in relation to the police station?
Block and a half away.
And how long did it take you to drive from the scene to the police station?
Less than 5 minutes.
And can you just clarify, why did you decide to move the scene to the police station?
There are several reasons. One, it's safer to conduct the investigation in a controlled jail than it is to conduct a DWI investigation in the middle of the roadway, where anyone could come by, get hit, or cause an accident, get involved in an accident. Conditions are better, flat, even jail floor as compared to roadways where they're kind of in the ground or anything like that. And then also, our DWI task force officer was occupied already, was unable to make the scene, and what did I meet with him at the jail.
Take past the loose, John.
Hold on a second. You said when he got out of the car, he stumbled back or crashed or something?
When he woke up, he took it. The vehicle was in drive with his foot on the brake. So once he woke up from us rocking the vehicle, he took his foot off the brake and rolled into my backup officers.
So it rolled in, it actually crashed into the other car?
Yes.
Okay, all right. That's the only thing I wanted clarification. Okay.
May I proceed?
Please.
Good morning, sir.
Morning.
So can you describe in general your role in this investigation?
I was the first officer on scene, and I was one of the dispatch and responding officers to it.
Okay, and fair to say that he was in pretty deep sleep, right?
Sure.
And at the scene, very little time was spent with Mr. Alfaro, is that right?
Yes.
Okay, now, you said that you've done approximately 5 DWI investigations?
Yes, but that's what it was.
Okay, but you've done your NHTSA training.
Yes.
And you know that the second stage of the NHTSA training is called the personal contact stage, right?
Mm-hmm.
Do you recall what that is?
I do not.
Okay. You know that in any investigation, it's important to spend time with the person that you're investigating and try to distinguish illegal from legal behavior, right?
Absolutely.
And in kind of big picture terms, that's one of the things that the NHTSA manual teaches you how to do, right?
Mm-hmm.
Is that yes?
Yes.
Because it's not illegal to drink and drive. It's only illegal to drink and drive while you're intoxicated, right?
I'm not necessarily having to drive my belt and detainer and other violations as well.
Well, we can agree that in not all.
About DWI, then yes, I would agree with you.
Okay. In general, not every time that somebody drinks after having consumed alcohol, not every time are they committing a crime, right?
Correct.
Okay. Now, in this case, you were dealing with somebody who was deep asleep and was roused out of sleep, right? And it wouldn't be surprising if that person exhibited things like red eyes, right?
Yes.
Yes, it would not be surprising?
It would not be surprising.
Okay. that they appeared maybe a little bit disoriented, right? And you say that his speech was slurred, but you had never met Mr. Alfaro before, so you don't know how he normally talks, right?
Yes, sir.
Okay.
I know what slurred speech sounds like.
Okay, but would it surprise you that especially on the station where the audio is more clear, his speech doesn't appear slurred at all?
That would surprise me.
All right. So in the time that you spent with Mr. Alfaro at the scene, that wasn't enough to distinguish whether the symptoms were from alcohol intoxication, possible alcohol intoxication, or just being roused out of a deep sleep, right?
I will not know. That's why I'm arrested for DWI right there.
I understand that, but in general, after such a brief amount of time, that wouldn't necessarily be enough to convince yourself that this is just a person that I've woken out of a deep sleep, right?
With other factors, I would disagree, but I mean, there's a possibility.
All right. Did you write an offense report in this case?
I wrote the supplement report.
One moment, Judge. Judge, may I confer with the prosecutor for a second? Okay. Your offense report actually doesn't say anything about arresting him for impeding a roadway, does it?
My supplement does.
And Officer Rohrer, who was the lead officer in this case?
Officer Rohrer was the one that worked the DWI investigation.
Okay, and it was his understanding that the scene was being moved to the scene to continue the DWI investigation. Is that right?
Objection, Your Honor, speculation.
If you know.
I don't know what Officer Rohrer put in his report, but I'm not going to tell you what was in his report.
Ask the witness.
Anything further?
Yes, Your Honor, briefly, thank you. Officer, was this a public roadway?
Yes.
And were there any other facts that you said it initially that because of the defendant being asleep, you had suspicion of a DWI potential? So were there any other facts that gave rise to further suspicion of a DWI in the course of your
encounter? My whole encounter?
Yes.
I mean, there was the strong level of alcohol and everything from him. I spoke with him and asked him if he had anything to drink, to which he told me he had a few. So he had admitted drinking, I could smell it on him, his sort of speech.
Stay past the witness, Your Honor.
Nothing further, Jeff.
Someone mentioned something about an open container. Was there an open container or no?
No.
No. Okay, all right. You are excused. Subject to recall, anyone?
Subject to recall, please.
Okay, if you don't mind, please just waiting outside in the jury. Step. Okay, state any other witnesses?
Yes, Your Honor. The state calls Brian Rohr to stand.
Great. Do you mind grabbing reputation?
All right, witness, not being sworn in.
All right. Deputy Rohr, if you don't mind coming up to the witness stand and raising your right hand.
Sir.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, please do take a seat. If you don't mind to speak loudly, clearly, if you hear the word objection, just stop until we address it, and then you may continue.
Yes,
Okay? All right. State, please.
Thank you, Your Honor. Can you please state your full name for the record?
Brian Charles Ward.
And what do you do for it?
I'm a police officer.
How long have you been doing that for?
About 4 years now.
And do you have to have any specialized training to do that?
Yes, sir.
Can you briefly describe that training?
The basic police officer's course is about 9 months of specialized training is mandated by TPOL, as well as I'm a member of our DWI task force as well, which is further specialized training.
And what kind of specialized training do you have that DWI to be part of that DWI?
We would be part of our DWI task force. You have to have basic SSD, standard skills sobriety tests. You also would highly encourage you to a ride course, as well as you have to be certified as a drug recommended expert within 1 year of your posting.
And how long have you been a part of the DWI task force specifically?
About 1.5 years.
And over what years, one as a police officer, how many DWI investigations have you been involved with?
I'd say at this point, probably upwards of 150.
And generally speaking, I know everyone's different, but how long does it take you to complete a DWI investigation?
Generally about 2 to 3 hours.
And do you remember, do you recall the incident that we're here for today that occurred on July 7th, 2024?
Yes, I would.
And can you explain how you became involved with that?
With a call service, officers went out, found the reason was people stopped in a roadway. They had reasonable conceit to believe a DWI investigation needed to take place. I couldn't make it out to the scene, so the subject was actually transported up to our top room to me.
And upon contact with the defendant, what did you notice?
I noticed eyes were red, also detected odor of alcoholic beverages and some slurred speech.
And what did you do next?
Next was going into the DWI investigation, which would be Miranda's questioning and then sobriety tests.
Do you recall the specifics of your investigation as far as the Center for Sobriety Test?
As far as the specifics in clues specifically for the assessee?
Generally, yes. If I were to ask you about the clues that he exhibited, would you recall that?
I would probably have to reference the reporting.
So you just have one moment, you want to? Sure. Let's do that. First witness, Cheryl?
Yes.
You recognize?
Go ahead. Yes, I do. And it's my original voice from the United States. Would like to refresh your recollection.
Officers, your recollection refreshed?
Yes.
So you made contact with the defendant and you said you began to carry out your investigation.
I'm sorry, say that again.
You made contact with the defendant and you began to carry out your investigation. What was the first step in that process?
So I'm sorry. First step of the process would be an interview of the subject.
Okay. And what did you learn from that interview? Okay, we're going to skip that. We're going to go to the standardized field sobriety test. What was the first standardized field sobriety test you carried out?
The horizontal gaze and awareness test.
Okay, and what is that test?
That test checks for the involuntary jerking of the eyes.
Okay. And what were the results of that test?
The result on that were 6 out of 6 validated groups.
What are those 6 clues?
The first one is a lack of smooth pursuit. Then following that is a distinct and sustained nystagmus and maximum deviation, and then the onset of nystagmus prior to 45 degrees.
And it's fair to say that he hit all 6 of those clues.
That is correct.
And what does that indicate to you?
That would indicate the presence of a substance in this.
Can you, would that indicate alcohol, potential presence of alcohol in the defendant's system?
Yes,
And what did you do next?
next was the walk-in turn test.
Okay. And what is the walk-in turn test?
The walk-in turn test is one of the psychophysical tests where it splits the subject's mental and physical capabilities to possibly see if a intoxicated individual would have difficulty splitting those.
And what were the results of this test that you did?
On this test, I observed 2 out of 8 validated groups.
And what did you do next?
Next was the one-leg stand test.
Great. And what is the one-leg stand test?
Again, it's another psychophysical test. Testing the subject's ability to count while balancing on one leg.
And what were the results of this test?
On this test, I observed 0 of 4 validated groups.
And what did you do after that?
After that would be reading the subject DIC 24.
Based on the totality of the circumstances, were you able to form an opinion on whether or not the defendant was intoxicated?
Based on the totality of circumstances and the results of my investigation, I did form an opinion that he was intoxicated and had lost the mental and physical capabilities required to safely operate one of them.
State best of the witness, Your Honor.
May I proceed, Judge? Good afternoon, sir. Or good morning, I should say. You wrote in your report that Mr. Alfaro was transported to the Pasadena jail for further investigation after he was detained at the scene. Is that right?
That is correct.
Okay, so it was your understanding that he was transported to continue the DWI investigation, correct?
That would be my part of the investigation, yes, sir.
Okay, he wasn't under arrest for anything else as far as you were aware of?
As far as I know, when he was transported, he was placed under arrest for traffic offense.
All right. Now, you mentioned that it takes 2 to 3 hours to complete a DWI investigation. Can you break down exactly what goes into that?
So in those 2 to 3 hours in that estimation, I would be including initial contact of the subject, interview, observation, or possible interview of initiating officer, my interview with the subject, the SFSTs, as well as the collection of a forensic specimen and typing the report.
Okay, but really, when you're talking about an arrest, the relevant portion is usually much shorter than that, right?
That is correct.
So you're talking about maybe the personal contact stage and then the pre-arrest screening stage, right?
I'm sorry, I don't understand the question.
Well, I mean, the point at which you get enough evidence to confirm that somebody's intoxicated or disconfirm that somebody's intoxicated is much, much shorter than 2 to 3 hours, right?
Yes.
Because that takes into account booking procedures and things like that, right?
Correct.
Okay. Now, this wasn't a situation where there was an emergency going on, right?
No.
Okay. Even though you're the more experienced officer, Officer Johnson is actually certified to administer field sobriety tests and has done so in the past, correct?
That is correct.
Okay. There wasn't a language barrier or anything like that, right?
Not to my knowledge.
And in fact, the intersection where this all happened, I mean, there were parking lots, drugstore parking lots, places where DWI investigations are sometimes conducted, right?
Yes.
Okay. So, in other words, there was nothing to stop the DWI investigation from being conducted where it was there at the scene of the incident. Nothing that you can point to, is there?
As far as the performance of SFS teams, no.
So what was the reason for moving this investigation to the jail?
to bring him to a member of our DWI task force who is better suited to performance of the SFSTs and to provide a space more conducive to performance of the SFSTs.
Okay, but if you had wanted to, it could have been this, or if, not you personally, but if law enforcement in this case had wanted to, this investigation could have been pursued more diligently.
Objection, Your Honor, speculation.
If there's a lot of sufficient space in a safe place, that again has sufficient space and level ground to perform the SFSTs, i.e. a space and level service more conducive to performing the SFSTs safely, then yes, it can be.
So it could have been done more diligently, correct?
It could have been possibly performed by the officer on scene.
Okay. Pass the witness.
Officer, approximately how long did this investigation take you?
This investigation, in terms of interview and arriving at a decision of intoxication, I would say approximately 40 minutes.
And typically, are DWI investigations faster or slower if you or another member of the DWI task force conducts the investigation, rather than a member of patrol unit?
There it is, the best advice you'll hear all day. The judge waived thousands of dollars in fees for this guy, but he's making it crystal clear. This is the one free pass. In Texas, a DWI is $1 billion industry. They track it, they fine it, and they watch for it. That line about the surcharge. If you don't pay it, you sit in jail for $100 a day. So seriously, if you're going to get lit, take the Uber. It's cheaper than sitting in here.
It is significantly faster.
State passes the witness, Your Honor.
Nothing further, Judge.
All right, witness may be excused. All right, thank you, sir. State anything further?
Just argument, Your Honor.
Okay,
Judge,
so hold on. You rest?
Yes, Your Honor, statement.
I'm going to admit a thumb drive with 2 body cameras and then the scene body camera. And I'm not going to publish this right now. I'm going to offer it as a part of the record. And I don't have anything to stick it with, but we can call this Defense Exhibit 1.
Have you seen this? Do you know what it is, State? And do you have any objection?
I mean, it's just body cam from the scene, we were in Your Honor.
Okay,
That should be.
all right. It'll be admitted. Defense 1?
Defense 1, Judge.
Okay.
And with that, we rest.
Okay. Argument.
Thank you, Your Honor. Your Honor, the state offers 3 arguments here. First is that clearly under the traffic code, Officer Johnson had probable cause to arrest the defendant at the scene for the traffic violation. Upon arrival, the officer could clearly see that the defendant was parked in a moving lane of traffic in violation of traffic code section 545-363 and 545.302. That arrest is clearly authorized under traffic code section 543.001. And after that arrest, once the officer had transported the defendant, then a separate DWI investigation took place, which is clearly legal and proper and does not violate any of the defendant's Fourth Amendment rights. And the alternative, Your Honor, the state would also show that the officer articulated sufficient facts to rise to at least reasonable suspicion that the offense of driving while intoxicated had occurred. The defendant displayed a strong amount of alcoholic beverages, was asleep in his vehicle, and took significant effort to wake up from the officers. Also, the time of night was indicative, and the other facts that the officer suggested, such as slurred speech and the other surrounding circumstances. Furthermore, moving the investigation to the police station and subsequent time it took the investigation. Furthermore, moving the investigation to the police station and the subsequent time it took to move the investigation was reasonable under the circumstances and served a legitimate law enforcement purpose. That purpose was to give the DWI investigation to an officer that would be more efficient at running the investigation. This purpose, this is supported by prior case law in Belcher v. State, where, Your Honor, the Court of Appeals out of Fort Worth found that a 30 to 35 minute prolongment was reasonable under the circumstances for the express purpose of the officer handing the DWI investigation over to a specific DWI officer for the purpose of efficiency. Furthermore, Your Honor, the state in the alternative to that argument would also go to show that probable cause existed at the scene due to the totality of the circumstances and the signs of intoxication and the clear operational facts that the officer had at the scene rose to the level of probable cause for the officer to arrest the defendant for the crime, for the offense of driving while intoxicated.
Can you come up real quick, Blaze? Come up, Mr. Devil, come up. Sure, on the record. Okay. As a lawyer, as a person who just works in general, I really take pride in what we do. You know, when we do stuff, we come prepared. This is not a joke, man. This dude that just came and testified now was a deer in headlights when you asked about the interview. Completely and wholly unprepared in every single way. So I don't give any credence to that testimony right there whatsoever. I mean, it's like, how are you going to come? This is not a joke. You know, we take this completely serious. You know, you come here, you can't even recite what happened. You can't even take 5 minutes to look at the damn report. You know, really. So that, no credence whatsoever. So what I'm going to do now is I'll take a look at the facts surrounding what happened on the scene, and I'm going to make a decision and see whether we go forward or not. But I'm floored how you're just going to come in and just kind of, here, let me just, you know, really, it's not a joke. It's a life on the line here. And I really take it seriously, and I'm just offended by it. So anyway, I don't need it.
All right.
Let me just take a look. I want to see that real quick. And then I'll have a decision here within a couple hours. Okay?
All right.
All right.
Thank you, Judge.
Thanks.
May we be excused?
Please.
Right.
All right, lawyers, let's go. Just don't, just, it is what it is. You know,